Welcome to today's webinar. For those of you who don't know me, I'm Melanie Costin and I'm the leader of the Estates Division here at Vincents. Today I'll be addressing the primary implications for lawyers in relation to tax and deceased estate administration and providing practical solutions to some of these issues. If you have any questions along the way, please feel free to log them and I'll do my best to answer them, but I'm under a time constraint, so if I run out of time, I'll contact you after the webinar to assist you with your queries that you may have. So the first thing is, why is the tax important? Like, as lawyers, why do you need to alert your client to the importance of addressing any tax matters? The primary reason is the executor is personally responsible for finalising the tax affairs of the deceased and the estate. This includes lodging any outstanding prior year income tax returns of the deceased, lodging a final return for the deceased. This is what we refer to as a date of death return, which goes from 1 July to the date of death, lodging any trust income tax returns for the estate, discharging any associated tax liabilities that result from these returns, and providing beneficiaries with the information they need to include in their own returns, and in certain cases paying tax on the beneficiary's behalf. As the executor is personally responsible for finalising the tax affairs, it also means that if the assets of the estate have been distributed to the beneficiaries and there is insufficient assets remaining to cover any tax liabilities, the executor is personally liable for the debts. The estate may have tax debts due to a number of reasons, including the deceased already had an existing debt at the date of death, the deceased has outstanding tax returns that when prepared result in a tax payable, the executor may not be aware of the tax implications of the different types of estate assets realised, and a tax event may be inadvertently triggered by the way in which the executor and beneficiaries agree to distribute the estate. In the situation where there are not enough funds in the estate to pay the tax debts, I've seen this play out in a number of ways over the years. I've seen the executor go back to the beneficiaries with their tail between their legs to ask for money. I've seen the executor take responsibility and pay the tax debts out of their own pocket. And I've also seen executors stick their head in the sand and pretend it doesn't exist. It'll be interesting to see how those ones play out as the ATO has wide-reaching data matching capabilities. Another reason why it's important to address any tax matters is family harmony. I've seen instances where if parties have been aware of the tax consequences, it's likely that they would have made different decisions. And I've seen family unrest where beneficiaries agreed to take certain assets in specie, believing that they were taking their sort of equal share in the estate. However, the embedded tax was not taken into account. I should also note that the accountant in the tax office isn't always the bad guy. We've recently had a number of estates where the lodgement of the outstanding income tax return has resulted in significant refunds to the estate. So tax isn't always bad news. So why get the accountant involved early with the estate administration? This is my first practical tip for today. It's not uncommon for lawyers to wait until the estate is fully administered, well, all but fully administered, with only a nominal amount left in the trust account, addressing the tax issues at this late stage. But leaving it to that point, the potentially put the executor at risk of being personally liable for any tax debts if the estate has been over-distributed, and it can also cause significant delays in finalising the estate. There are a couple of good reasons to get the accountant involved early. Even as early as when you're applying for probate, we can be advising on whether the deceased has any outstanding tax debts and any outstanding income tax returns. We can also prepare these returns at that stage. I've also found that the parties involved have a vested interest at that point in assisting in locating information. Once it's got to the point that the beneficiaries have received the bulk of their inheritance, they're less interested in going to the effort of finding some of that information that we may need. The second good reason to get involved early is due to the ATO processing times. For example, if the tax file number of the deceased cannot be located, The great news is that we can get this from the ATO and confirm the deceased tax status, but it's taking about 5 to 8 weeks for the ATO to provide this information. It can also be worthwhile getting an estate tax file number early on. For example, when an interest earning bank account is opened, an estate TFN will need to be provided to the bank to avoid TFN withholding tax. You don't want the executor providing their own TFN, as the interest earned may be incorrectly declared on their personal tax return rather than that of the estate. And also with the ATO pre-fill data that's available these days, if the wrong TFN's on there, then the ATO at some point will be sending out a letter to that executor saying that they haven't declared that interest. To get an estate tax file number, we can apply for that online, and it takes, at the moment, it's taking about 2 weeks for the ATO to issue that TFN when you do the online application, which I've heard doing it by paper takes about 1 or 2 months to actually get that TFN. It's also prudent to get the accountant involved early, as we can be proactive in advising on the tax implications of administering the estate, such as what if certain assets were sold, what if they were transferred in specie, what if there are non-resident beneficiaries, what if there are charities that are beneficiaries. Tax information regarding these different scenarios up front can allow the parties involved to make informed decisions. So up to this point, I've talked about the executor's responsibilities to discharge any tax debt. But I also mentioned about the executor having to provide information to the beneficiaries so that the beneficiaries can include the distribution in their own personal tax return to pay the tax. So what determines when the estate should be paying the tax, when the beneficiaries should be paying the tax, or when the estate has withholding obligations on behalf of the beneficiary? The key factors to consider are whether the beneficiaries have received net income, so are they presently entitled, the type of income, and the type of beneficiary. So now I'm going to look at the concept of present entitlement and the income and the beneficiaries in more detail. So when we look at present entitlement, understanding when a beneficiary is presently entitled is an important concept that affects who declares the net income and who pays any tax payable. If a beneficiary is presently entitled to income of the estate, then they are responsible for declaring the income and paying any tax. If a beneficiary is not presently entitled to the income of the estate, then the estate is responsible for declaring that income and paying any tax due. When determining who should pay the tax on the income, the Commissioner of Taxation takes into consideration the stage reached in the administration of the estate, the terms of the deceased's will or codicil, trust law principles and orders made by the court, and whether any discretionary payments have been made to the beneficiary. Expanding on the stage of administration, the Commissioner of Taxation refers to 4 main stages. On the death of the taxpayer, the beneficiary has no interest in the estate assets. Then the Commissioner sees that there's then an initial stage when net income of the estate is applied to reduce debts. At this point in time, there's still no beneficiary presently entitled to the income. Then the estate reaches the intermediate stage, where net income of the estate that is not required to pay debts may be paid to beneficiaries. In these circumstances, the beneficiaries are presently entitled to the income to the extent of the amounts actually paid to them or paid on their behalf. The fact that the estate has not been fully administered does not prevent the beneficiaries in this situation from being presently entitled. Then during the final stage, as the Commissioner sees it, debts are paid or provided for in full, and net income of the estate is available for distribution. Residuary beneficiaries at this point are considered to be presently entitled to the income derived by the estate. The difficulty with present entitlement is that it's not always clear-cut, and the concepts need to be applied and the specific circumstances of each estate taken into consideration. Now that we've considered the first key factors as to who pays the tax, now we need to look at the type of income that's in the estate. So, like most things with tax, there's exceptions to the rule. So, superannuation death benefits and death benefit ETPs, which are employment termination payments, if they are received by an estate, they are amounts which no beneficiary is presently entitled. That is the way it's always treated. It doesn't matter if the estate has paid the super proceeds or the ETP proceeds out to the beneficiary. It's just always treated as no beneficiary presently entitled, and the estate pays the tax. If the estate receives the super death benefits, as I said, the estate pays the tax on behalf of the beneficiaries of the superannuation. The amount of tax is the same as if the payment was made directly to the beneficiary, excluding any Medicare levy. A Medicare levy on estates. The tax on a superannuation death benefit depends on whether the person receiving the benefit is a dependent or non-dependent of the deceased. So this non-dependent is what's driving the tax on these particular types of income. So looking at who is a dependent, for this particular purpose, a dependent is a spouse, which includes a legal spouse or de facto, current and former spouse, a child of the deceased who was under 18 years of age, any other person who was financially dependent on the deceased, any person who had an interdependency relationship with the deceased, or if the deceased was a member of the Australian Defence Force or Police Force and they died in the line of duty, any recipient of the superannuation, regardless of their relationship with the deceased, is treated as a dependent. So the good news is, if you're a dependent, there's no tax on any lump sum superannuation death benefit the estate receives. So if you're a non-dependent, there's tax payable. When the estate receives a superannuation death benefit, a PAYG summary should also be provided by the super fund. The PAYG summary confirms who the death benefit has been paid to, whether it's the estate or directly to a beneficiary, the components of the amount, whether it's tax-free, a taxed element or an untaxed element, and the amount of tax withheld. A tax-free component is not subject to tax. A taxed element is subject to a maximum tax rate of 15%, so it's capped, and on an untaxed element, that's capped at 30%. In relation to tax withheld, where the payout is made to the estate rather than direct to a non-dependent, the super fund is not required to withhold tax. This is why I found that super death benefits are one of the most frequent tax traps for the executor. Recently I was involved with a small estate, it was only about $240,000, but there was a tax liability of approximately $60,000. This is because the estate consisted solely of a superannuation death benefit, and it was predominantly an untaxed element where you're paying that tax up to 30%. In that particular instance, the executors were managing the estate themselves, and prudently they got me involved early as they suspected there were tax consequences. But some other estates I've been involved with haven't worked out as well because they'd already distributed the estate proceeds and had over-distributed the estate because they hadn't taken into account the tax liability. Now, when it comes to the death benefit ETPs, if that's received by the estate, the analysis is similar to receiving a superannuation death benefit in that the estate pays a tax on behalf of the beneficiaries. The amount of tax is the same as if the payment had been made directly to the beneficiary, excluding the Medicare levy. The tax on the death benefit ETP depends on whether the person receiving the benefit is a dependent or non-dependent, and the definition of dependent of the deceased for the tax purposes is the same. Similarly to the superannuation death benefits, when the estate receives this ETP, a PAYG summary should also be provided by the deceased employer. In this case, it confirms, once again, who is it being paid to, the components, which are either tax-free or taxable, and the amount of tax withheld. Similar again, tax-free component, no tax on that. But for the tax payable, a taxable component depends on whether the beneficiary is a dependent or non-dependent. For a dependent, tax is only payable on the amount above the ETP cap, which is currently $195,000. For a non-dependent, tax is a maximum of 30% up to the ETP cap, and then highest marginal tax rate above that cap. Also, in relation to the tax withheld, where the payout's made to the estate rather than direct to a dependent or non-dependent, the employer is not required to withhold tax, which can become a tax trap, again, for the executor. So the third factor to consider when looking at who's going to pay the tax is the type of beneficiary. At the start of the presentation, I mentioned one of the executor's responsibilities is to pay tax on behalf of the beneficiaries in certain circumstances. If the beneficiary is presently entitled, but they are a non-resident, under a legal disability, or have not quoted their tax file number, these beneficiaries should only be paid after tax amounts, as the estate has withholding obligations to be met. A person under a legal disability includes a minor under 18, a bankrupt, or a person declared legally incapable because of a medical condition. The executors are responsible for withholding and submitting tax on behalf of the beneficiary. This involves a registration process with the ATO, calculation and submission of correct withholding tax amounts, as there are different rates for residents and non-residents, and there are also annual reporting obligations to be met. So to close the loop on who pays the tax, is it the estate or the beneficiaries? After consideration is given to the specific circumstances of the estate, including whether the beneficiaries are presently entitled, the type of income, the type of beneficiary, the end result is either the net income of the deceased estate is taxed to the estate, or the beneficiaries who are presently entitled, if they are Australian residents for tax purposes, not under legal disability, and they've quoted their tax file number, or the estate is required to withhold tax on behalf of the beneficiary if that beneficiary is a non-resident, or they're under a legal disability, or they haven't quoted their tax file number. One of the things I mentioned earlier on was about the executor's responsibilities to provide information to the beneficiaries so that they can include that distribution in their own tax return. All beneficiaries must be provided, well, when they're presently entitled, must be provided with details regarding assessable income amounts and share of tax credits associated with the income. Taking credits, TFN withholding, and foreign tax credits are the most common. For a beneficiary that's presently entitled but under a legal disability, they will also need to know the amount of tax paid on their behalf. If they need to lodge an income tax return, they will be entitled to receive a tax credit for that amount that's been paid for them, so it means they aren't taxed twice. When you've got a non-resident, due to the different types and rates of tax that apply to them, they will also need to know the amount of interest in their distribution and the withholding tax paid. This is usually 10% withholding tax, unfranked dividends, and the withholding tax. With the withholding, it does depend on the particular country, but unfranked dividends are generally 15% withholding. frank dividends in their distribution, and the tax that the trust paid on their behalf for any other types of income. It is important to provide this information in a timely manner, because if the beneficiaries have already lodged their own personal income tax return for a particular year and then they have to go and amend it to include this distribution, usually results in people being unhappy. So far we've talked about who pays the tax, so now I want to move on to some of the tax events that may be unexpected or inadvertently triggered by the way in which the estate is distributed. When thinking about reasons why an estate may have income and associated tax consequences, we generally think of things like interest or dividends received by the estate, a rental property, sale of property, or sale of shares. But there doesn't necessarily need to be a sale to trigger a tax event. Certain in-specie distributions can have the same effect. The general rules that the legislation provides in relation to capital gains is that the capital gain or loss on an asset is disregarded when it passes in specie to the executor and on to a beneficiary. If a testamentary trust is involved, the Commissioner of Taxation has a long-standing practice of disregarding the capital gain or loss on assets when they pass in specie to the executor, to a trustee of a testamentary trust, and on to capital beneficiaries of the trust. However, the capital gain or loss is not disregarded if it's purchased by the deceased, which is a post-CGT asset, so that's an asset purchased after the 20th of September 1985. If that post-CGT asset is distributed in specie to a tax-advantaged beneficiary, then that capital gain or loss is not disregarded. And to make it even more confusing, that deemed capital gain or loss is not accounted for in the estate tax return. It is included in the deceased final tax return, that date of death return. So when the Commissioner refers to a tax-advantaged entity, in this particular circumstance, they're talking about a tax-exempt body, such as a charity, a complying superannuation fund, or a non-resident. And where the issue of the capital gain being triggered is where the asset is not taxable Australian property, which is only specific to the non-resident beneficiary. So going into a bit more detail regarding that, starting with the tax-exempt bodies. A tax-exempt body may be endorsed to access tax concessions, but they may or may not be endorsed as a deductible gift recipient. For example, Queensland Cancer Council or Guide Dogs Australia is endorsed as a deductible gift recipient, whereas organisations such as Rotary or the deceased local church may not be endorsed as a deductible gift recipient. When transferring post-CGT assets to a tax-exempt body, the deemed capital gain or loss is only disregarded if that charity is a deductible gift recipient. This is where it is important for the accountant involved early to advise on the tax implications so informed decisions can be made. If possible in these circumstances, consideration should be given to whether the asset should be sold by the executor and cash distributed or to transfer the assets in specie. If, for example, the charity is a DGR, sale of the assets by the executor would trigger capital gains tax, whereas a capital gain or loss on an in-specie distribution would be disregarded. If the charity is not a deductible gift recipient, the capital gain or loss on an in-specie distribution would be included in the deceased date of death return. Further, there is no tax deduction for testamentary gifts, so there's no tax deduction to assist in offsetting any capital gain that may be triggered. This situation could be advantageous or it could be problematic depending on the circumstances. If, for example, the deceased had capital losses or revenue losses, these could be used to offset the deemed capital gain. However, it can also be problematic if the deceased had no losses. What if there is limited cash or other assets that can be liquidated in the estate to pay a tax liability which has been triggered in the deceased date of death return? I'm not going to talk about the super funds being a beneficiary today because it's not a common occurrence. So moving on to the non-residents. The CGT consequences for a non-resident beneficiary are determined by whether the assets are taxable Australian property. The Income Tax Act has a convoluted definition of what this is, which I'm not going to bore you with today. Instead, I just want to talk about the most common CGT assets that I see inherited by a non-resident beneficiary, which are real property and publicly listed shares. If the real property is situated in Australia, it's taxable Australian property. If the real property is situated outside of Australia, well, it's easy, it's non-taxable Australian property. But the one that catches people out are CGT assets such as publicly listed shares, which are considered to be non-taxable Australian property. If the asset transferred in specie is taxable Australian property, the capital gain or loss is disregarded. If the asset transferred is non-taxable Australian property, the deemed capital gain or loss is included once again in that deceased final tax return, the date of death return. The key is to make sure you're aware of the tax implications on any non-resident beneficiary distributions that are being proposed. Say, for example, it is proposed that non-TAP assets, specifically a post-CGT share portfolio, may be transferred in specie to a non-resident beneficiary. This would trigger a CGT event in the deceased date of death return. As with the issue with the charities, this may be suitable if there's minimal capital gain on the assets or the deceased has carried forward revenue losses or capital losses. However, this might not be ideal if the estate has minimal cash or there's minimal assets left to liquidate to get the cash to pay any tax liabilities that might be triggered. Another asset that can have unexpected tax consequences for the executor or beneficiary, if they've taken it in specie, is the deceased main residence. I quite often hear that the property was always mum and dad's house, so there won't be any tax on that. If the estate disposes of the dwelling within 2 years of the date of death, there will be no capital gains tax, as a full exemption will apply. But be mindful that the 2-year deadline applies to settlement date and not contract date. If the estate's getting outside of the 2-year period, full or partial CGT exemption may be available depending on the circumstances, but there's a number of factors that need to be looked at to determine the extent of that exemption, which includes the timing of events in relation to the dwelling, whether the dwelling was used to produce income, and who has been living in the dwelling after the deceased's death. Okay, another new sort of tax trap is the foreign residents capital gains withholding. So this is a new holding regime which may catch executors and beneficiaries unaware because it's quite new and it's for contracts entered into or after 1 July 2016. At a high level, the regime means where a foreign resident disposes of certain taxable Australian property, the purchaser will be required to withhold 10% of the purchase price and pay that amount to the ATO. The main issue in relation to deceased estates is that the measures do not just apply to sale transactions. Transfers into the executor's name and transfers to the beneficiary may be caught by the withholding provisions, and it can also apply to the transfer of joint tenancy. The other key issue is the regime assumes that the transferor is a non-resident unless a clearance certificate is obtained. In the case of transfers, this means the executor and or beneficiaries will either have to obtain a clearance certificate or variation certificate or be liable for that withholding tax. If the executor intends to sell, this means they will need to apply to the ATO for a clearance certificate if they want to ensure that no funds are withheld from the sale proceeds. A certificate can be applied for at any time when considering disposing of real property. When the certificate is issued by the ATO, it's valid for 12 months and is it obtained on the ATO website online. Some certificates are coming through in a couple of days, but if there's irregularities, this can be delayed. The good news is that there are exclusions. One of the key exclusions is for transactions involving real property with a market value of less than $2 million. The exclusion can apply to residential dwellings, commercial premises, vacant land, strata title units, easement and leasehold interests, as long as that market value is less than $2 million. But note that this exclusion does not apply to indirect interest in Australian real property, such as shares in a company or units in a trust that hold real property in Australia. For direct interest, there is no threshold. A declaration must always be obtained by the purchaser. The other main exclusion where the withholding rules do not apply is to transactions conducted on an approved stock exchange. So now, the last two things I'd like to talk about is what if the will includes a testamentary trust or the provision for a special disability trust. Starting with a testamentary trust, it's a separate trust to the deceased estate, and so it's going to need its own tax file number. And best to get this early again because you don't want the trustees declaring their own personal number. The two main benefits of the testamentary trust are asset protection and the tax effectiveness. So in terms of the tax effectiveness, usually income can be distributed to a range of beneficiaries, but it depends on the terms of the deeds. And minors are taxed at concessional rates, which is adult marginal tax rates. If a minor was to receive a similar distribution from an inter vivos trust, they would be taxed at top marginal rate rather than getting the adult rates. So in terms of what income can be taxed to minors at the concessional rates, the legislation refers to resulted from a will, indicating that assets of the deceased may be viewed as seed assets. So this would involve income from the following assets being okay, which is ones that were owned by the deceased at date of death, assets purchased from the sale of assets which pass to the estate or testamentary trust, assets purchased from income generated from the assets of the estate or the testamentary trust, and assets purchased with funds borrowed against the assets once they're in that testamentary trust. However, income from assets gifted to a testamentary trust by other living parties will not qualify. It's important to note that testamentary trust isn't just a free-for-all to get low tax rates with children. The legislation which drives the concessional rates, which is Section 102 AG, has its own anti-avoidance provisions. The legislation specifically disallows minors being taxed at adult rates if the transactions were not done at arm's length or the agreement was entered into for the purpose of securing the concessional tax rates. So in this regard, if parents or grandparents want to provide for the education and maintenance of their children or grandchildren, I usually recommend drafting budgets in relation to the ongoing contributions to school fees, books, excursions, clothing, sport, health, any other sorts of expenses on the kids, and actually distribute the cash for that purpose. And the other thing that I also mentioned earlier was with the CGT and a testamentary trust. Although the legislation does not specifically address the situation, the Commissioner of Taxation has a long-standing practice of disregarding the capital gain or loss on assets when they pass in specie to the executor, to a trustee of testamentary trust, and on to the capital beneficiaries of the trust. So as you can see, there are a number of ongoing benefits in relation to a testamentary trust. An accountant plays an important role in ensuring the ongoing compliance and maximising the benefits of the structure. In terms of trusts established under a will, the other specific type of trust I wanted to talk about is a special disability trust. This trust provides asset protection for a specified beneficiary. And specifically, a special disability trust is a trust that is established either pre or post-death, usually by parents and immediate family members, for the future care and accommodation needs of a person with a severe disability. In terms of the will, it may include the option of the inheritance going to a special disability trust. The will may actually include the special disability trust deed, or if an inheritance has been left directly to someone who's severely disabled, there's a 3-year window in which that money can be contributed to a special disability trust if that's an appropriate structure. So the key benefits of the special disability trust. Firstly, got the asset protection there for the beneficiary. If there is assets transferred in specie into that trust, there's a capital gains tax exemption. There's a Centrelink gifting concession of up to $500,000 for eligible family members of the beneficiary. This provision is useful in the estate planning phase. For example, parents on an aged pension could establish the trust whilst they're alive and contribute up to $500,000 without their aged pension being affected. There's a Centrelink assets test exemption, which is indexed annually. The current limit is $647,500 as of the 1st of July 2016. This, combined with the usual asset limit for receiving a disability support pension, means it can be up to $800,000 roughly invested in the trust without affecting the beneficiary's support pension. All income earned in this trust is excluded from the Centrelink's income test. If the trust purchases a main residence for the beneficiary, it is exempt from Centrelink's asset test. There is also a capital gains tax exemption for the main residence, and depending on the state legislation, transfer duty exemptions may be available in relation to the main residence as well. One of the other advantages is a beneficiary is able to work up to 7 hours a week and still receive the trust concessions. If their employer is part of a supported wage system, there is no limit to the number of hours the beneficiary can work. The catch with the Special Disability Trust is that there are strict eligibility criteria and also strict rules regarding the use of funds in the trust. To be eligible to be a beneficiary of the Special Disability Trust, the person with the disability must meet the definition of severely disabled under the Social Security Act, which is assessed by Centrelink. And there are strict boundaries on what the funds in a special disability trust can be spent on. So the limits are to spending the money on reasonable care and reasonable accommodation of the beneficiary. So in terms of reasonable care, this type of expenditure is unlimited as long as it is based on the beneficiary's disability or it's at a medical practitioner's request. If there's any other expenditure on the beneficiary, this falls under discretionary spending, which the current limit on that at the moment is $11,500. This expenditure is usually to meet additional costs relating to the beneficiary's health, well-being, activities they might like to do, their independence and other social activities. But like all things to do with the government and Centrelink, you must rules. If you don't stick to the rules, the trust could be ruled non-compliant, which means the beneficiary could potentially lose their social security benefits. In addition, the trust will lose its tax concessions. However, through the effective management of the trust, through budgeting and monitoring the expenditure, it's easy to maintain the compliance of the Special Disability Trust. If there is a potential for establishing one of these trusts, Centrelink should be contacted early on to check if the beneficiary is eligible. If the beneficiary is eligible, we can assist with getting the trust approved by Centrelink and provide tax advice regarding proposed distributions. This way, by the time you as the lawyers have called in the estate assets, the trust is approved and ready to receive the estate distributions, whether that be in cash or in specie. So as discussed throughout the presentation, getting the accountant involved early is of great benefit in reducing the risk of the executor being personally liable for any tax debts if there's been an over-distribution. The executors and beneficiaries having information to make informed decisions about tax, minimising delays in finalising the estate, and assisting with the establishment and ongoing compliance of structures such as testamentary trust and special disability trust. Also, providing the correct information can save you a world of pain. To assist in this process, we provide on our website forms, which I've given you the website address there, which make it quicker and easier for you to request our services and to know what information to provide. We in turn can provide a speedy resolution to these tax matters. Also, we've got fixed fee for some of the services, or we're happy to do an agreed quote so that your client's budgets can be maintained. So that brings today's presentation to a close. If you have any questions, please feel free to contact me on my details here below. And any questions that have come through, because I'm short of time, I'll get in contact with you shortly to help out with that. So thank you very much for listening today.